Two government documents can look identical. They carry the same stamps, the same official signatures, and mandate the same compliance. But one requires an immediate lawsuit to stop it, while the other requires an internal appeal first. Guess wrong, and the court dismisses the case before hearing a single fact. In Thailand, the executive branch wields the power to alter the rights and obligations of private citizens through unilateral state action. For legal practitioners, identifying the actual legal nature of a state document is a matter of professional survival. Misclassifying an order results in an immediate loss of the right to challenge it. The trap springs when a lawyer identifies a specific administrative act as a broadly applicable rule. They file a lawsuit directly, skipping a mandatory internal administrative appeal, and the administrative court strikes the case down on procedural grounds. A citizen's access to justice depends on identifying the actual operational effect of an order. The printed title at the top of the page is often legally irrelevant. Relying on it is a fatal error. To navigate this, we must isolate the three categories of state power: the Administrative Act, the Rule, and a hybrid known as the General Administrative Act. All three are unilateral exercises of public power intended to create binding legal effects. Their operational mechanics diverge based on two specific vectors: the target of the act and the concreteness of the situation. We can plot these actions on this structural matrix. The y-axis maps the scope of persons, ranging from a specific individual up to the general public. The x-axis maps the scope of application, from a concrete, isolated case to an abstract, continuous standard. Mapping state acts against this matrix is the only definitive way to avoid the procedural trap and secure the correct legal remedy. We start with the Administrative Act. On the x-axis, this act applies to a concrete, isolated situation. On the y-axis, it is directed unilaterally at a specific, identifiable person or entity. An example is an official government announcement granting a state scholarship specifically to Mr. A. Even if the document is titled Announcement, the mechanics target a specific individual for a specific grant. That operational reality overrides the document's name. Because this act targets one person in one concrete case, the law requires the aggrieved party to file an internal appeal with the agency before they can step foot in a courtroom. At the opposite end of the spectrum is the Rule. On the y-axis, a rule applies generally to the public or to an open-ended class of people. On the x-axis, it establishes an abstract normative standard rather than addressing one isolated event. Take a regulation establishing standard housing allowance rates for all civil servants. This regulation applies continuously. It automatically attaches to anyone who eventually meets the criteria, functioning as a permanent standard rather than a one-time grant. It is entirely abstract. Because rules dictate broad standards, aggrieved citizens can bypass internal administrative appeals and challenge the rule directly in the administrative court. This brings us to the category that routinely leads to misclassification: the General Administrative Act. This hybrid has the broad applicability of a rule, but the concrete specificity of an administrative act. Consider a police order banning all traffic on a specific road, like Soy 459. While a traffic ban applies to everyone, it targets only a specific physical object, that one road, rather than establishing a general behavioral standard for the country. Similarly, consider an order temporarily closing specific sports stadiums during a pandemic. The stadium closure applies to anyone trying to enter, but it is strictly limited to a concrete situation and specific physical locations for a discrete period of time. Confusing this hybrid with a broad rule is a primary cause of misfiled administrative lawsuits in Thai courts. To understand why this hybrid is so problematic, we have to look at the history of the statutory text. The Thai Administrative Procedure Act adopted its core structural logic from the German administrative legal system, translating European doctrines directly into Thai law. But there is a divergence. German law explicitly defines the General Administrative Act, the Allgemeine Verfügung, in its statutory text. When Thailand imported this system, lawmakers omitted the definition for the hybrid category. The concept exists in the structure, but the written code is missing. Because the definition is missing from the statute, Thai courts and practitioners must rely on academic theory to interpret the law. This omission forces legal debates over whether a temporary traffic ban or a localized public warning should be treated as a rule or an act. Importing a foreign legal framework without its definitional keystone creates an environment where practical justice is stalled by theoretical confusion. The Thai legal system is now attempting to repair this statutory gap. A proposed draft amendment aims to officially codify the General Administrative Act into Thai law. This draft explicitly defines orders that target identifiable groups or regulate the public use of specific property, mirroring the mechanics of our structural matrix. This statutory fix will align Thai legal reality with its intended theoretical framework, closing the procedural trap. This is the completed matrix. All three actions are unilateral exercises of state power that alter private rights. Their classification depends on weighing the concreteness of the case against the specificity of the target. For legal practitioners, the lesson is absolute. Never trust the title printed at the top of a government document. Protecting a client requires stripping away the nomenclature to map the actual operational mechanics of state power. That is the only way to ensure a citizen's right to judicial review survives.